Good morning, good afternoon, or good evening, depending on where you are accessing this on-demand recording from. Welcome today. We are so excited and so privileged to have Abby from Americans for Safe Access. Abby is their Director of Government Affairs, and she will be discussing the ASA State of the States report. Of course, this report does focus in on the medical marijuana regimes from state to state. Abby is going to take us through the particular sort of how they come up with scores for each state and the particularities of how they arrive at the grading scale that they have come up with. Really fascinating set of information for us today, and just a lot of great information about specific jurisdictions. So Abby, without further ado, I'm going to hand it over to you and turn my camera off, and we can't wait to hear what you have to tell us.
Great, thanks. Hi, everyone. Thank you for watching this presentation. This is about the Americans for Safe Access State of the State report. We look at the medical cannabis laws in every state, and we judge them based on a rubric for how well they protect and serve patients in the state. So this will be a rundown of those policies, some of the nuances that we look at, as well as things that you should pay attention to if you're working in advocacy or with the legislature, or even things that you should know about your state laws that may not be apparent just from the surface that you would need to know in practice. Quick introduction to myself. My name is Abby Raudebush. I'm the Director of Government Affairs here at Americans for Safe Access. I work on both the federal and state level and in the United States territories to promote access to medical cannabis, make sure that products are safe and affordable, and that no matter where you live across the United States, you have the access to this treatment option that you should. A note about ASA, Americans for Safe Access. We are the largest national organization of patients, caregivers, medical professionals, scientists, researchers, and other concerned citizens to promote safe and legal access to cannabis for therapeutic use and research. We are the major nonprofit organization focusing on the patient voice and strictly on medical cannabis legislation, regulations, and policies. Obviously, there is a big trend nationwide in the states and also a big conversation on the federal level about recreational adult use. Americans for Safe Access does support those laws, but we are focused on medical cannabis laws and the protections that patients may be afforded that are not included in recreational adult use laws. So just to preface this presentation, I am only talking about medical cannabis laws in certain states. Other states that do have recreational adult use laws, we don't consider those states when we grade the medical, or we don't consider those laws when we grade the medical program, because they really are distinct and they should remain distinct. One serves patients while others serves the recreational market for adults. Both deserve a place in state and federal law, but we are just really focused on the silo of the medical cannabis laws. Just want to preface that as we dive deeper into our report card. Americans for Safe Access has published State of the State since 2014. It is a yearly report, so every year we update all the state laws that have passed and taken effect, and we incorporate that into the grade for the state. This does include every United States state and US territory. So we grade Guam, Virgin Islands, DC, Puerto Rico, all of the rest of the territories, and include them as well. Our rubric is based on a full spectrum of patient rights, what we would consider an ideal law. We probably wouldn't consider this a perfect law because there are just so many aspects that go into making sure that patients are protected and have the access that they deserve. And there's no way that we can capture that all in the rubric, but we do try to capture the most important parts and a wide spectrum of access and policy issues that may impact different groups within the patient population. We also every year publish within each scoring category what we call the gold standard state for that category. that simply means that that is the state that received the highest score this year in that category. It does not mean that that state is perfect in that category, or that that is where every other state should strive. There are some gold standard states that received 100% in some categories. Even they could do additional things better that we didn't grade. And we do provide recommendations for each state and territory for things that they can do in the coming years to improve their program. And we also try to specify where they should put their focus, what the most pressing issues are. And like I mentioned, this is updated yearly. We only take into account laws that have actually gone into effect by the end of the calendar year. So the report that's coming out this year looks at all the laws that have gone into effect by December 31st, 2021. Any law that went into effect January 1st or that is passed this year and goes into effect will be in next year's report card. So that's also something to keep in mind. Now onto the rubric. We grade on a number of different categories, including patient rights and civil protections, to make sure that patients have the rights, legal rights that they deserve when they are using legally under the state law. We look at access to medicine. This looks at, are dispensaries available? What kind of products are they able to buy? Are there dispensaries close to somebody, or do they have to travel far? We also look at program functionality, which is more of the administrative side. This category definitely impacts patients and their day-to-day use of programs, but is largely looking at how the government functions with licensing and things like that. That obviously the better they are with licensing, the more retail locations are open, which expands access to patients. So it's important for us to look at how the program actually works on the back end. We also look at affordability. Every year, this is one of the biggest things that we hear from patients about problems that they're facing with medical cannabis is the affordability, either strictly the affordability of the product that they're buying, but it also includes other things like program costs. How much does it cost them to go to a doctor and get a doctor's recommendation? How much does the registration cost? How often do they have to register? Are any background checks involved? Things like that. We also look at health and social equity. This is looking to make sure that no matter your race, your sex, your economic position, your geographic location in the state, looking at all of those to make sure that underserved populations are served. In this, we also look to see if states have any social equity programs within ownership of retail businesses. This is important to make sure that states are creating a open market, one that doesn't bar people from joining because of past criminal convictions, especially if they have to do with cannabis, which is legal in the state once they pass medical cannabis, at least the medical use. And looking to make sure that there's not a financial barrier for citizens to start companies themselves, making sure that it's not just big companies and corporations coming in. We also look at consumer protection and product safety. This is a very big and important category, looking at what kind of testing does the state require for industry businesses from seed to sale. So from cultivators, manufacturers, retailers, we look at all of those to see how often it goes under testing, what kind of fail-safe programs there are. We also look to see what kind of training the staff gets, which is equally important if they are working in a medical cannabis field. And then lastly, we also this year have added a penalties section. Sometimes states, well, let me start by saying in the rubric for every other category, they're awarded for what they do. They just simply don't receive points if they don't do something. But there are certain points, like not limiting THC if they have a CBD only law, if they have administrative or supply problems that make it really hard to get products and things like that. If they classify cannabis as a medicine of last resort, those things are really harmful to patients. So the penalties section was created this year to actually penalize and deduct points from states that do those extra harmful things, to deduct their score for that. So what the message we're really trying to send is, you can be doing a lot of things good, but if you're also doing these things, that undercuts your program entirely, which is why they're penalized for them this year. A note about the grading scale: it is graded on a 100% to 0% grading scale. This is not like an academic grading scale where 50% or higher is passing and 50% or lower fails automatically. Our rubric is very tough because states should be doing a lot for patients, and right now states are not. So the grading scale was adjusted more so to acknowledge what a wide breadth of laws there are out there, and that states like Idaho or Nebraska that still completely prohibit any kind of cannabis, those obviously fail, but other states that may receive a 55% do actually have a medical cannabis law, and so it didn't make sense to have them be the same grade. So for our grading scale, 100 to 90, this means that this is a very comprehensive program and it provides substantial patient rights and protections. The law may not be perfect. There are some slight changes that they should make, but overall, it is a very comprehensive program that takes patient rights seriously. A B is 89 to 70. This is a good medical cannabis program. It is still a great grade to have on our grading scale, which you will see in a second. But these laws do require a few major adjustments to ensure that patients are protected. The C range is 69 to 50. This is a fair medical cannabis program. It provides some access and protections for medical cannabis patients, but there are substantial improvements in one or more areas that need to be made. A lot of states, you'll see lost points in affordability in that section. A lot of states also lost points in consumer protection and product safety. So those are really the areas in some states that really need to be beefed up. That's where they're losing a lot of points and where they may otherwise be a good medical cannabis program. A D is 49 to 30. This usually means they have a medical cannabis law on paper, but there are some serious flaws with it that mean patients either don't have access because they have to drive too far, or there are no retail locations open at all, or there are some huge patient rights policy issues that were just neglected in the passage of the law that are really critical to ensuring that a medical cannabis program works. And then an F is 29 to 0%. This usually means that there's either a non-existent medical cannabis law. A lot of states that have the CBD only medical cannabis laws do end up falling in this category. There may be a few that have passed what they call a medical cannabis law, but when you actually look in the state and see how it's practicing, it is essentially the same as not having access because so many things are missing. Some top line data and key insights from all of our grading. Our highest grade was a B plus, an 88.83%. That was Maine. The average score across all the states and territories was a D plus of 47.21%. So as you can see by that, overall as a country, we are not doing great on the medical cannabis laws. And even though states have passed medical cannabis laws, the work is not done, and we still need to protect patients and make those laws better. On the left, you can see that, we didn't have any state that reached an A. As I mentioned earlier, the rubric is very tough because it's what we would consider an ideal law. And so it is made by design that an A is not easy to achieve. Only 6 states fell in the B category. I am very proud of these states. These states do have pretty good medical cannabis laws in each of them. The majority of the states did fall in the C range. Over half of the states fell in C and D ranges together, and 14 states did receive a failing grade this year. So what this tells us overall is, even though a lot of people cite the number that I think it's 36 or 37 states now have medical cannabis laws, what we clearly see from this grading is that doesn't mean that our work is almost done. It really means that the work that all of us do, the work that I do here at ASA advocating for patients in these laws, is really just beginning, because we really are striving to have 56 grades at an A+. I think that's all of the states and territories added together. So we continue to, this is why we continue to do the work that we do. So now I'll go into each category and I'll break down the things that we grade, maybe explain a few of them and give some top line insights so you guys can understand what we look at, what we consider a perfect law, or an ideal law, I should say. And before I dive into this, I do want to mention that this report, when it is published, it will be out very shortly, will be sent to participants. It will be sent to INCBA. It is also available on Americans for Safe Access website, where you can get that information. It's available in a digital version. You'll be able to order a printed version as well if you want that. In that report, you'll be able to see the report card for all of the states and all of the territories, including what they scored in each of these categories. So I encourage you to take a look at that. It will shed a lot of insight, specific insight onto what I'm talking about broadly today. So to dive into civil rights and patient protections, first we look at arrest protections. Arrest protections and affirmative defense kind of go together. The arrest protections are making sure that if they have a patient card, their patient registration card, and they are pulled over, they're searched, or they're caught somehow by law enforcement with having cannabis products or cannabis paraphernalia, that they are free from arrest, that they will not be arrested for that. A lot of states do provide this. Surprisingly, some states don't. And I will point out that it's worth 25%. It's one of our most important protections in this category. Affirmative defense obviously kind of goes hand in hand with that. If for some reason a patient is arrested or charged or given a citation, anything like that, they can present their medical cannabis registration as an affirmative defense to that charge or citation. A lot of states do provide this. I think more states probably provide this than provide arrest protections, but still very important. Another one that may be less thought of when thinking of civil rights is parental right protections. In some states, your status as a medical cannabis patient can be used against you in family court when you are seeking custody arrangements, or if you're in family court for any reason, when they take best interests of the child into consideration, they are allowed to consider the fact that somebody is registered as a patient, and that can be used against them. So some states have started to add these protections into their laws. I'll say, I think a majority of states do not have these protections. Some states go halfway, where you can't present evidence that just being a registered patient, that can't be used against you, but they can give evidence that your active use is harmful to the child. But what we're looking for are full parental protections. If you're using a treatment like medical cannabis or any other treatment for a medical condition, it should not be counted against you in things like family court. We also look at employment protections. These come in two varieties. The first is anti-discrimination policies at the hiring level, and at the employment level as well, making sure that somebody cannot be discriminated against simply for being a registered medical cannabis patient. The other one is drug test protections, either a pre-employment drug screening or ongoing employment drug screening, that testing positive for THC as a medical cannabis patient is protected, making sure that you can't lose your job or you can't find a job just because you're a patient and you test positive for THC, which you are allowed to use. Another one that's becoming more of a trend, unfortunately, the trend is going the wrong way with legislators talking about it, is DUID protections, driving under the influence of drugs. I find that legislators, regulators, policymakers are very, very concerned with this. And so they're quick to want to make some kind of law where if you're suspected of driving under the influence of cannabis, you are given a blood test. And if you test positive for THC, then you are automatically guilty for driving under the influence of drugs. However, as I'm sure we all know, if you are a medical cannabis patient, if you are somebody who uses medical cannabis on a regular basis, you will test positive even if you are not actively under the influence at the time. So these laws, without taking a person's medical status into account, are discriminatory against patients. This is something that we're trying to emphasize to the states, but unfortunately, a lot of them are going the wrong way and enacting laws that are harmful to patients. We also look at whether the program provides explicit privacy standards to make sure that your health information, your health status that the state collects is kept safe and private, just like all your other medical information. Excuse me. For this category, Delaware, Illinois, Maine, Minnesota, South Dakota, and the US Virgin Islands were our gold standard states. They scored a 90% in this category. Illinois is one of the states that they sort of provide half parental protections and half employment protections. And the rest of the states lost their points because they don't provide any parental right protections. So those are the areas where those states can improve upon. The average score across all of the states and territories in this category was only 57.47. So, as I said at the beginning, a lot of states can really make a lot of improvements in this category. For access to medicine, we look at whether the law authorizes retail access, which may seem common sense. It probably is common sense, but not every state medical cannabis law actually authorizes retail access, gives patients a place to actually purchase their treatment options. So that is one thing that we continue grading. We also look at alternative accessibility methods. This means this category has two subcategories, each worth 10 points. The first is whether they allow delivery. This is important, especially for patients with chronic conditions or illnesses that make them unable to travel distances, whether they have epilepsy and don't have a driver's license, or whether they have MS and they have mobility issues, or if somebody is undergoing chemotherapy and is just simply too sick to leave and go anywhere. Are dispensaries allowed to deliver to patients in the state? And then we also look at whether the law allows for curbside pickup, which again benefits patients by allowing a staff member of the dispensary to run the order out to the car, and helps patients, especially those with mobility issues, stay in their car. I will say both of these delivery and curbside pickup were two major things that most states did immediately when COVID-19 first started. When the shutdown started, most states declared their medical cannabis programs essential, and they provided for delivery and curbside pickup, which was mostly for, social distancing and safety. But a lot of these states have moved to make those permanent and leave them working for patients, because they saw that just those little changes, even though they didn't do it initially for necessarily the patient needs, they saw that it was such a great benefit that they have started keeping them. So that is something that we're grading now. We also look at whether the law allows personal cultivation. This is really important to ASA. This could also fall under the affordability category, although we grade it under access. If somebody is allowed to grow their own plants, we know that if a person is allowed to grow their own plants, there are a lot of things they can control, including the cost of their monthly medication, as well as their supply. Many state medical cannabis programs have some significant ongoing supply problems. Others have intermittent supply problems, depending on things going on with the program. So if people are allowed to grow themselves, then they have a steady supply of their own treatment option. Then we also see if the law allows for collective gardening. If you're not able to grow at your own place for some reason, is there a place that you can go and grow with other people? The biggest thing in this category for access to medicine is whether a state has a sufficient number of retail licenses. There was a trend for a while of some states passing medical cannabis laws and only allowing 4 or 5, 10 maybe dispensaries for an entire state, which is not at all adequate. It leaves a lot of patients in dry areas where they do not have access to that treatment option. And a lot of times those end up clustered near cities. So we look at whether the state provides a sufficient number of retail licenses and whether they have an ongoing process to approve more retail locations. Another big thing for this category in access to medicine is reciprocity. If you're a medical cannabis patient, or if you are a patient who strictly uses traditional pharmaceutical medicines, you know that your medical condition does not stop when you cross state lines. And while you are able to travel with your traditional pharmaceutical medications, it is against federal law to cross state lines with cannabis, even if you were going from one medical or recreational state to another. So we make sure that states provide reciprocity. The best kind of reciprocity is the kind that allows you to take your state card into a medical dispensary in another state and use that state to purchase cannabis under the state's laws. Some states require you to fill out paperwork and register with the state. Some states only allow reciprocity from other states. So we look at what kind of reciprocity is allowed and how they treat visiting patients. Colorado and Maine are gold standard states for access to medicine. They do a pretty good job. They got an 80%, but do have some major things that they could improve upon. The average score for this category was a 39.47, one of the lowest average scores for all of our categories. And this is something, in addition to affordability, that we hear a lot from patients. Access to medicine is something that is quickly apparent to a patient who is trying to navigate the system, and it is very important in making sure that they have easy access to medicine, to make sure that patients are not having to forego any treatment option because they can't simply get to a dispensary. Program functionality, this is a pretty big category for us. There are a lot of things that we look at from the state side. The first is whether it provides legal protections in a reasonable time. The states differ across the country. Some of them, as soon as you submit your registration to the state, you have protections and you're able to begin growing. Some of them, as soon as you register on the state, you are able to access a actual medical cannabis registration card virtually on your phone. Others, as soon as they approve your medical cannabis registration, that's when your protections kick in. There may be a little bit of an administrative delay in approving your recommendation, but as soon as they do, even before you receive the card in the mail, you have protections. And then there are some states where you don't have protections until you receive your card in the mail. You have to have the physical card. And I will say it seems like a trend in those states is the states that require you to have a physical card in order to get protection seem like the states that take the longest to approve the registration in the first place, which is just something that we noticed as we were grading. I'm going to take the next two together, reasonable possession limits and reasonable purchase limits, because they really are connected. It's really important that states don't have low monthly purchase limits. We need to make sure that patients of all kinds have access to enough cannabis to treat whatever it is they're treating per month. Again, we don't want patients to forego any treatment option. This is just like if somebody is forced to ration their pills for a condition. We don't want anyone to be in pain or anxiety or experience seizures or anything like that because they weren't able to purchase enough. At ASA, we consider 5 ounces a pretty good monthly purchase limit if they're going to have one in the law. ASA does prefer that there is no monthly purchase limit and that this is left up to the patient and their caregiver, but if the states insist on putting one, it should be no lower than 5 ounces. Reasonable possession limits goes along with this. Well, one note on purchase limits first, we also recommend that you allow patients to be able to purchase an entire month's supply at one time, especially in those states where access to medicine is not great and people may have to travel far distances or make a lot of plans to get to the dispensary. Somewhere where it's not easy to, pop in and buy medicine. It's really important for people to be able to purchase an entire month's supply all at one time. And then the possession limits go hand in hand with this because we need to make sure that patients are able to travel, especially travel around the state with their treatment options. So the possession limit needs to be at least as high as the monthly purchase limit. Again, so if somebody does go to the dispensary and buy an entire month's worth of product at one time, they're not then violating the possession limit and in legal jeopardy there. We also look at telemedicine for physician certification. This is another thing that was enacted quickly when COVID-19 first hit and the lockdown started. They made telemedicine for not only the initial certification to get your patient registry, but your recertification. They allowed that for the first time in a lot of states. I will say, unlike delivery and curbside pickup, the telemedicine for certification is something that more states have allowed to lapse and they no longer allow it. However, for the same concerns for delivery and curbside pickup and why those are so beneficial to patients, the same goes for telemedicine, making sure that patients have access to a doctor wherever they are, whether they're at home and can't make a special trip to another doctor's office, or if for some reason they just can't make it to a doctor's office, we need to give them the ability to get their certification that way, especially since most certifications for medical cannabis, either one come from your treating physician, your primary physician, your specialist, or come from another doctor, but does not require a physical examination. So it's fine to do the vast majority of these recommendations on telemedicine, and this is a common sense solution to help patients actually get access to this program. Another big one for program functionality is making sure that there is patient and physician representation in the program decision making. A lot of states have set up a special committee or commission that looks at expanding qualifying conditions, looks at other things in the program, makes decisions on whether something should or should not be allowed. Some states that have these committees, unfortunately, those committees are made of mostly law enforcement personnel with no patient or physician representation on those bodies. The most successful bodies that actually make big, real life, very beneficial changes to patients are those committees and commissions that have physicians and caregivers on them and participating in the decision-making process, because they obviously bring a very critical perspective to this program. We also look at reasonable caregiver standards. In some states, caregivers are required to undergo a background check. If they require a background check, then states only get half points for this. And if they require caregivers to pay for their own background check, then they don't receive any points at all. Ideally, a caregiver, just like a patient, should be able to register with no other qualifications on it other than being a caregiver of a medical cannabis patient. We also look at reasonable physician standards. What kind of, sorry, my cat is making an appearance. What kind of requirements are on physicians? Do they have to undergo any special kind of training? Is there a special registration? Is there an ongoing certification that they have to participate in? What we're looking for are standards that ensure that physicians in the state are well-versed medically in cannabis, but something that is not too onerous that most physicians don't want to deal with. We want as many physicians as possible to feel comfortable offering medical cannabis as an option to their patient if a patient is interested. We also look at access to administration methods. So this is what kind of products are allowed in dispensaries. Is it edibles and tinctures only? Do they allow topical ointments? Do they allow the sale of actual flower, smokable products? Do they allow vaping? Things like that. It's important to make as many different kinds of administration methods available to patients as possible, because not everyone treats their condition in the same way. Some things work better for people than other things, and vice versa. There's no one size fits all administration method or treatment option for cannabis. It's really dependent on the patient and their condition. And so we need to make sure that they have access to the full range of products as possible. And then this last one, access to minors on school grounds. Here at ASA, we recognize that this is primarily a federal issue. A lot of things, including the Drug-Free School Zone Act, don't allow schools to give students access to medical cannabis, because that would violate the Drug-Free School Zone Act, because cannabis is still Schedule I at the federal level. And we have seen the federal government rescind grants in some states because they did try to allow cannabis in schools. Nevertheless, a lot of state legislators are taking this upon themselves to try to find a solution in the absence of any kind of federal movement on any kind of cannabis at all. So we did want to have a line on here that awards state legislators who are trying their best in a situation where the federal government should have acted a while ago. I'm happy to report that Maine does have 100% in this category. This is really great for Maine. Also, one of the reasons why they are the top scoring state of this year. although the average score across all of the states is a 60.84. So there are quite a few states who could learn from Maine's lead and work on the back end of their program and making sure that things are reasonable on those ends. We also take a look at affordability. As I mentioned at the beginning, this is a very important category for patients. It's the most common issue that I hear patients talk about when they talk about having access to medical cannabis. So we first look at whether there's a sales tax break for medical cannabis patients, especially in states where there are recreational adult use programs. A lot of those states tax the recreational adult use heavily. We want to make sure that patients are not taxed heavily. Ideally, there will be no sales tax or excise tax on medical cannabis, whether or not the state has a recreational cannabis law. It's really important that the state is not making a profit off of patients' backs, people who are simply trying to afford their medication. And especially in states that have a recreational adult use program, that is an avenue in which the state can make revenue and make sure that patients are not shouldering any of that burden. The next one, covered by a health state insurance or health program. I'll be honest, I don't think a single state got these points this year, but this is one of those things, like I said at the beginning, our rubric is based on what we consider the ideal law. And we are encouraging states to move to make sure that under state insurance, medical cannabis products can be covered. But also we want to make sure that these visits to physicians to get your certification for cannabis can be covered as well. Right now, unlike any other treatment option, there's no insurance out there that can cover it. So everything from going and getting your physician certification to any product that you buy is completely out of pocket, and in addition to your other health expenses that you have from month to month. So we need to make sure that the state does their best to alleviate as much of this as possible. So in future years, I very, very much look forward to awarding 20 points to states in this category, but unfortunately we did not this year. We also look at reasonable registration fees. Again, patients should not be funding the state's medical cannabis program. They shouldn't be funding anything else in the state for trying to afford their treatment options. However, we understand that there are registration fees. So without a doubt, if there's no registration fee, they got full points. If the registration fee is $50 or less per year, we went ahead and awarded them full points for this category, but they really should make it free. And some states, these registration fees can reach up to $200 or $300 per year, and those states received no points in this category because that is such a high hurdle for patients. And that is just a fee to pay for you to even be able to step foot in the dispensary and then begin paying even more for the product. So we also grade whether financial hardships, waivers, and discounts are given. Again, a lot of states, most states do have registration fees, but do states provide for low income waivers or discounts to make sure that citizens are not financially barred from registering in this program? And again, this is really important for states to do, not only to make sure that patients are not shouldering the financial burden of a medical cannabis program or any other program in the state, but it's also very critical in making sure that people actually have access and that you're not actually only giving access to people who can afford it. We want access for all, not access for all who can afford $200 a year. And on that same note, we also look at whether there are any donation programs. Products can be very expensive. They add up quickly throughout the month and then throughout the year. So does the state provide for any kind of donation program for low-income individuals to actually receive products? And then we also look at whether states allow multi-year registrations. It is a financial and time burden and really unnecessary to make patients get a certification every single year to continue their use. So do states allow multi-year registration to help alleviate that burden from patients? Big note about affordability. I will just assume everyone believed me that we do hear that affordability is the biggest problem for patients every year. But just to illustrate this even further, our quote unquote gold standard state for affordability was Illinois, but they only received 65% of the points in this category. So I'm hesitant to call Illinois our gold standard state. Technically, they are because they receive the highest grade, but they have some substantial work they need to do. And this is reflected also in the average score across the country. It was only 39.69. This is the lowest category out of them all, and is something that states really need to put a priority on fixing this and making sure that all patients have access. This year, health and social equity is a new category for us. We look at whether there are state program protections. Sometimes states do drug test their entitlement program beneficiaries, so their food stamp, WIC, things like that. If states do, unfortunately, drug test those recipients, then we look to make sure that there are explicit protections for medical cannabis patients so they don't lose their benefits simply for using the medical cannabis program. I will say that most states don't drug test entitlement program beneficiaries, and I wish no state did, but most states did receive full points in this category because they just don't drug test for those programs. Then we also look at housing protections. This is for tenants. Not everyone owns their own house. Obviously, if you own your own house, you are free to do whatever you want in it, but this is for patients making sure that they are not discriminated against when they're applying to housing, and making sure that they cannot be evicted for behaviors that are allowed under the program. So using cannabis, if they're allowed to grow cannabis under the program, things like that. Just a note about this line, we're only talking about those housing protections that the states can actually legislate and provide protections for. This does not include those individuals who live in federal housing, anything that falls under the jurisdiction of HUD on the federal level. Unfortunately, those protections have to be given by the federal government, and they have not indicated a willingness to do so, but we are urging them to. We also look at whether there's access to minors. The big thing here is one, making sure programs are not available to those who are 18 or 21 or older, but also making sure that you're not making minors jump through extra hoops, making sure you don't require them to get a second or third opinion before they can get their registration, when adults don't have to get that opinion. Also looking for access in underserved areas. So in the access to medicine category, we look at the number of retail locations in the state, but in access in underserved areas, we look at the location of retailers in the state, making sure that there aren't huge geographic regions in the state that have no access or no dispensary close to it, making sure dispensaries aren't grouped in major cities, things like that. We also look to make sure that there are all-inclusive qualifying conditions. Some states only allow it for epilepsy, and we are glad they allow it at all. However, an all-inclusive qualifying condition list should really be for any condition your physician feels cannabis would benefit. We also look to make sure that patients can medicate anywhere they choose. Anyone who's ever been on any kind of medication or antibiotic knows that you have to take it on a regular basis. Sometimes you have to take medication at the same exact time every day, no matter what you're doing, and timing is really important. So we need to make sure that no matter where patients are, they are allowed access to their medication. And this does include in their home, whether they rent it or not. We also look at organ transplants. Unfortunately, some states do not allow individuals to be eligible for an organ transplant if they're also a medical cannabis patient. So someone could be using medical cannabis patient to alleviate pain or anything else that may be a side effect to the fact that they need a donated organ. And it just does not make sense that something they would use to treat a medical condition would bar them from something that would cure them. And then we also look at owner requirements. Again, we're looking at whether you're not barring citizens from entering this industry, looking to make sure that things like cannabis convictions are not disqualifiers, looking to see whether there are any explicit social equity provisions given in licensing. Some states do award points to social equity applicants and prioritize those. We also look at the health equity side of the owner requirements, making sure that the state hasn't said that, you can only be an X, Y, or Z city, things like that. Connecticut did a pretty good job in this category. They received an 85%, although the average score, again, super low, 45.20. And then I'll go on to consumer protection and product safety. This one is going to be short because I am not a scientist or a chemist, but thankfully we do have a chemist on staff who was able to make sense of all the microbial testing and everything like that required in the state. So what I will say is this category is broken down. We look from seed to sale. So we look at cultivation, manufacturing, dispensary, and laboratory requirements. And we look at a lot of the same subcategories in each of those. What kind of testing is required? What kind of safety protocols are there? What kind of staff training is there? Things like that. For this section, because I would not do a good job explaining it, even if I, spent many hours trying to learn about what all of the scientific stuff meant. I will say that in the beginning of the report on the digital version, we do have a very, very comprehensive category description for each of these categories and subcategories and what we're looking for and what we're grading. And so particularly on this section, I do encourage you to look through that. Nevada was the gold standard state for this. They received an 84%. The average score across all of these states was 40.75. I will say that a lot of states did lose a lot of points within this category overall, and is something that they should also be aware of. It's just as important to make sure that individuals are receiving a safe product as it is to make sure that they have access to any product at all. So states really should pay attention to their consumer protection and product safety protocols to ensure that the products on the shelf are patient safe. So the penalties category, the grim reaper of them all, a lot of these are pretty self-explanatory. I will say that while I did mention at the beginning that we do not grade adult use recreational programs, we do dock points from states that either give sole regulatory preference to adult use. So if they've stopped all of their work on medical cannabis altogether, or if a state has tried to combine their adult use and medical cannabis laws, we found in those cases that a lot of the patient protections were missed in those instances. And so they did lose points for that. Making sure that it's not classified as a medicine of last resort. It doesn't make sense to force any patient to try and fail a ton of medications before they can get something that they and their physician think will work for them. Vertical integration, this is something that I'm glad to say that a lot of states are starting to move away from. A lot of states that did require vertical integration from top to bottom have recently amended those rules. And so this helps open up the program to more retailers across the state. And then also big is making sure that they don't impose bans or limitations on CBD or THC. We know that different products, different levels work for different people. Cannabis as a treatment option is very individualized. So just like making sure they have access to all of the different administration methods, we need to make sure that they have access to a wide variety of ratios of cannabinoids and terpenes and things like that. And then quickly, I just want to add federal response and everyone's dreaded word, oversight. At the federal level, cannabis does unfortunately remain a Schedule I substance. This is something that I am working day in and day out to change, but that does create a big cloud over all of the state medical programs because they're only able to do so much in the face of federal inaction. Right now, there is absolutely no federal coordination or oversight or anything like that among all of these state and territory programs, which is why with 56 states and territories, we have 56 different laws. It takes a lot of effort to figure out if you're traveling somewhere what that law is, what you're allowed to do, what you're not allowed to do. It creates a lot of discrepancies across the country with the kind of access that patients can access. Even from employment and school and parental rights. So one thing ASA is working on, we would like to see a national federal coordinating agency. So this agency would pull in all of the piecemeal duties that individual agencies have right now, from FDA to HHS to the Department of Agriculture to Department of Homeland Security, all of those duties, everyone who has just the DEA, that's a big one. I don't even know if I mentioned that. All of the little things they have that do with cannabis, all of those would come under this one agency. And then that agency, we really need to set the floor minimum requirements for medical cannabis programs to ensure that no matter where you are in the country, medical cannabis patients can expect this minimum standard of care. And then another thing that we would like this federal agency to do is coordinate more medical cannabis research. I am sure anybody watching this is familiar that one of the most common questions that I get, one that you probably get, is what kind of research is out there? Can I see the research? And we know that it is really hard to do that research now because cannabis is Schedule I, which is why we don't have a lot of research. So that's something that we look to that federal coordinating agency to work on as well. So that was a not so brief overview of our State of the States report. As a reminder, this will be published at the end of January 2021. You can access the State of the States report on safeaccessnow.org/SOS. You should also be able to order a physical copy of that if you would like that as well. And also my email is on this final screen. It is Abby, ABBEY, @safeaccessnow.org. If you have any questions about the report or our methodology or anything like that, feel free to reach out to me and I'm happy to answer any questions. And also just my final note, I do really hope that you guys find the State of the States report beneficial. I personally find that it is a really great resource, a one-stop shop if you need a quick overview of a state law, or if you need to look at the national landscape of what something looks like. So please also let me know if you find it useful. I love to hear that as well. So thank you, everybody.
Abby, thank you so much. Just a wealth of knowledge and resources coming from ASA. Every time I hear the presentation, it gets better and better. We love how you score these states, and we are so thankful that you guys are out here doing this great work. If anyone does need to get a hold of Abby, please reach out to her or reach out to us here at the INCBA. We are always happy to help, and we are staunch supporters of ASA. So thank you again for your work, for everything that you do, and we will see you soon, Abby.
Thanks.